Last year, a big scandal rocked the Oregon Liquor and Control Commission when the Oregonian newspaper published an investigation revealing that executives in the agency, including the director, ordered bottles of rare liquor set aside for them to buy before the public could get it. Now the Oregon Department of Justice says there will not be criminal charges against anyone involved. Let's talk about why. First, here's what happened. In Oregon, the state buys and taxes all hard liquor, then sells it to independently operated liquor stores. That includes rare liquor that can cost hundreds of dollars a bottle. Only a handful of those rare bottles come into the state at a time. After all, they are rare. The initial investigation found that top managers at the OLCC would request to have some of the bottles set aside, reserved for them to buy before the public had a chance to buy them in a lottery system. After the story broke, the executive director of the OLCC, Steve Marks, stepped down at the request of Governor Tina Kotek, followed by OLCC board chairman Paul Rosenbaum. Rosenbaum claimed at the time that nobody on the board knew anything about it.
What did we know? Nothing. Nothing. There is not one person up here who knew a thing about the process, the procedure, the thing we're all discussing today. Not one. Not one. And if we didn't know about it, and we didn't, then how could we participate in it? We didn't. So stop asking questions about that. I'm telling you, nobody knew anything about this.
All right, well, pretty forceful statement. Give him credit for that. What the Justice Department found is that the practice of setting aside liquor, pretty much an open secret at the OLCC, one that went back decades, in fact. One employee told agents it had been going on the entire time she worked for OLCC, which was 30 years, and it started before she got hired. But no criminal charges will be filed for two big reasons. One, there was no specific statute against OLCC employees setting aside liquor for their own purchase, probably because no one thought you needed such a statute. The Justice Department says the records also between OLCC and liquor stores were a mess, and investigators could not prove who was actually buying what and who had made what requests. So here's what they looked into. The OLCC has a database that tracks the products in its warehouse. It's only accessible by OLCC employees and liquor store agents, so the employees knew if rare liquor was available. But there's no rule saying they can't just go ahead and share that information with anybody they like. Investigators talked to an OLCC distribution control manager who admitted to routing the liquor to specific stores at the request of multiple employees. Often they had them sent to a liquor store near their office. I mean, why not? The distribution control manager said she would then call the liquor store and tell them the product was being sent for a specific customer. But agents were unable to locate specific employees who made these requests. In the instance of the store near the office, for example, the store is now under new ownership and does not have sales records from the previous owner. Isn't that convenient? Investigators looked into the bank records of some OLCC employees, although they didn't specify in their report which ones. They were trying to trace specific liquor store purchases back to the OLCC employees, but in the end, they said they were unable to connect any of those purchases to a specific request to have booze set aside. Investigators did look into OLCC's communications records. They did find a specific request made in writing that a case be set aside to be purchased by OLCC executives. But then they say they looked at financial records and, really couldn't prove who had actually made the darn purchase. Investigators say they had a lot of trouble talking to employees, by the way. The ones on administrative leave after the scandal had lawyers who told them not to talk, and other employees had already quit. The DOJ says they considered a couple of charges, official misconduct, where a public servant knowingly does something unauthorized for their own use, and misuse of confidential information as well. Those are the two charges. They decided that this situation doesn't really meet the letter of the law because there was not a specific statute, again, prohibiting it, and therefore the employees didn't necessarily know that they were doing something wrong. The DOJ wrote in their report, even though the employee's behavior may have breached ethical standards, there is no explicit policy prohibiting the specific conduct. We found no evidence of relevant training, and the practice appears to have been longstanding and endorsed by at least one executive director. Also, the statute of limitations for misdemeanors is only 2 years, so the time to bring charges has pretty much expired. Now, there is a specific rule prohibiting employees from setting aside rare liquor, and the OLCC has changed up the way they offer it to the public with quarterly drawings, all of which will be recorded. So hopefully that'll fix things. Oregon Governor Tina Kotek sent out a statement saying that the documents from this investigation will be sent to the Oregon Government Ethics Commission for consideration in its review of the ethics complaints made in this situation.